Good evening. I hope you're all energized and ready for the next part, which is the most problematic part of this conversation. This is a big picture episode. Big Picture is a weekly show that we do at Africa Uncensored. I co-host it with Justine Wanda. Please follow us on Twitter, follow us on Instagram, TikTok if you can. By the way, this is live streaming right now as we speak on our YouTube and X. So this conversation is probably the one you are all looking forward to. And it involves the Cybercrimes Act and the Privatisation Act, the two most problematic laws that was recently assented by the president. Now, my name is Tom Mukwana. I am a journalist at Africa Uncensored. I co-host The Big Picture, as I mentioned. Today, I'm not doing this alone. I am joined by Waruguru Kiai, who is a lawyer. And aside from doing law, tonight she's dabbling as a journalist. Please take it, Waruguru.
Good evening once again. If you can hear me say hi. I also triple as a politician. So kuna vile, tialala.
We have
So what do you say? Vijana hi. No, it can't be like that. Vijana hi. At least.
Waruguru, there's
Yes.
two politicians now, Levi as well.
He's also a politician.
But you guys will wear that hat tomorrow.
So this evening, we shall be having a discussion around the Computer Misuse and Cybercrimes Amendment Act, as well as the Privatisation Act. And joining us in this very interesting conversation, we have Levi Munyeri, who is a wakili and he's an advocate of the High Court of Kenya, and he has a law firm, Kimani Kiari and Associates. Karibu sana wakili. Clap for wakili tafadhali. We also have Wakili Evans Ogada, who is an advocate of the High Court of Kenya, as well as a part-time lecturer and a researcher. Makofi kwake. We have Ray Ondaga, an advocate of the High Court of Kenya, and legal researcher at Katiba Institute. Let's clap for them. So before we start, I just want to hear from you. How many of us have heard about those two laws? The Computer Misuse and Cyber Amendment Act and the Privatisation Act of 2025. How many have heard about those two laws? By a show of hands. All right. So what have you heard? What have you heard about these two laws? Just stand up and say what you have heard. Yes, madam. Kindly stand.
There's a mic.
The microphone. There's a microphone.
What I've seen on Twitter is if your post hurt someone's feelings, you're going to be charged 20 million.
What else have we heard? Yes, sir.
Okay, I've heard something about Computer Misuse and Cybercrime Act, where the politicians have their version and the people also have their version. Yes.
Okay. Yes. Two more voices in the room. What have we heard? Yes. Pass the microphone.
Yes, hi. I've heard about the Privatisation Act. I've heard that it takes the power to sell state corporations from the MPs in Parliament to directly through Treasury. So from the MPs to the executive.
Okay. Last but not least. One more voice in the room at the back. Okay. So, of course, we have a lot of information surrounding these two particular laws, and we shall begin by having a discussion around the Computer Misuse and Cyber Amendment Act of 2025. And the first question will be posed to Wakili Levi Munyeri. Wakili, this principal act, kindly take us through the recent amendments. Take us through the good, the bad, and the ugly of the recent amendments of the Computer Misuse and the Cybercrimes Amendment Act. Karibu sana wakili.
Thank you so much. It's a great thing to be here today. This is a very amazing scene I'm seeing. At this time of the night, all of us are here, united in patriotism and care for our nation. I'm happy to be here. As you've heard, my name is Munyeri Levi. I'm an advocate of the High Court of Kenya. But most important, like all of you, I'm a very patriotic citizen. And that's the core reason I'm here today. As one of you has mentioned, there's a lot of controversy in terms of content of the Computer Misuse and Cybercrimes Act. That is an amendment. It was the amendment bill, is now the Amendment Act, enacted on 15th of October after the passing on of Raila Odinga. First things first, let me address two critical issues. One of my panelists here is a professor. He's always shy to say he's a professor. I'm very honored to be with you here today, Professor, one of the finest constitutional lawyers we have in this country, which will make me a little bit shy as I address the legal issues. First thing first, I'll first spend a minute or two to answer a very critical question that have been asked in different platforms. That question is, what is the role of lawyers in terms of challenging laws that have been enacted? This question stems from a very important principle we call separation of powers, that the government is actually has branches, being three major branches. One is the executive, that is the presidency. Second is the legislature, which is parliament enacting laws. And third is the judiciary. People have asked questions, why should you wait until a bill actually is enacted into law before you go to court to challenge it? There is a very important reason. It's because the law acknowledges that there is a separation between the judiciary and the legislature. The core function of the legislature is to enact laws. The core function of the judiciary is actually to interpret laws. Save for very narrow situations, it has actually happened once or twice in my practice of law, is you can challenge a law during the legislative process. That has actually been explained here so well. So as lawyers, we can only come in after the president has assented the law, in that the judiciary is not expected to interfere with the functions of parliament in terms of legislation. So that is very important, so that you don't blame or fault lawyers like ourselves for waiting until a law is enacted and signed by the president before you go to the High Court to challenge. There is a very limited aspect in terms of the function of the judiciary. They can only come in place after the law has been enacted and signed by the president. Second, a question would also be asked, out of these 8 bills that are now acts, why has a lot of attention been given to the Computer Misuse and Cybercrimes Amendment Act? The reason, in my view, should be one, or ought to be one. Freedom of expression is at the center of a democracy. We are here because of freedom of expression. We are here to express ourselves. And I believe that's why lawyers have given a lot of attention to the cybercrimes law, because even for us to have a discourse on the rest of the laws, including the Privatisation Act, the land laws amendments, we need to be given such a platform, online or offline, to actually deliberate on that issue. So anything that touches on limitation of freedom of expression comes to the foremost as a democratic nation, because without that freedom, there's nothing else you can deliberate on. So I'll come to the question I've been asked by my fellow panelists. It has been very confusing. I've heard statements by politicians, I've heard statements by lawyers, I've heard statements by the public about what exactly has been amended. So that's what I'll try to clear. There is the Computer Misuse and Cybercrimes Act of 2018. This is a law that was enacted in 2018. And then recently there's the Computer Misuse and Cybercrimes Amendment Act, which was now enacted recently. As it has been explained by a previous panelist, an amendment act comes to amend a mother law. So when you talk about the amendment, the Computer Misuse Amendment Act, it actually comes in force to amend the mother law, the Computer Misuse Act of 2018. And I'll say that it has been very limited and specific. A few amendments. Actually, the major ones that have caught the keen eyes of lawyers are actually two. As we speak, there are 4 petitions that I know of challenging specific sections of that Amendment Act. There is one by Ruben Kigame and Kenya Human Rights Commission. There is another one by the Law Society of Kenya. I've seen another one by those 2 are filed in Nairobi. There's one filed in Kerugoya by the women rep for Kerugoya, that is Njeri. And then I filed one at Kajiado Law Courts, myself being a resident of Kajiado. So I'll try to discuss the question I've been asked in the lens of those petitions. The mother sin, the original sin was committed in 2018. Hiyo kama ya Eve kukula fruit kwa garden. Hapo ndio shida zetu zilianzia. That's when the rain started hitting us. The Mother Act of 2018 is in itself unconstitutional, almost in its entirety, in terms of provisions. And what you've been seeing mostly circulating in the social media are actually provisions of the Mother Act of 2018. That act was challenged in court, I think by Katiba Institute or Kituo cha Sheria. They actually, Katiba Institute, thank you. They actually lost at the High Court. The matter, I'm told, is pending before appeal. There should be a judgment before the end of the year, which was challenging everything what you've heard about the fines. Those things emanate from the Mother Act. So when it comes to the amendment, there are 2 major amendments that have been flagged and actually constitute part of the 4 petitions I've mentioned that are pending in the High Courts in various towns. One and most important, perhaps, is the amendment to Section 27 of the 2018 Mother Act. And that amendment, as I had the Leader of Majority in Parliament mentioning, it's an amendment which adds to Section 27 essentially 4 words, likely to cause someone to commit suicide. So what happens, as I mentioned, the amendment adds, deducts, or varies the Mother Act. So someone would ask, what does Section 27 provide? Section 27 provides that any communication directly or indirectly from one person to another that is likely to cause fear, it is gross, they use the word gross, and now they have added this term, it's likely to cause someone to commit suicide, actually is an offense that, now this one is from the Mother Act, that attracts a fine of 20 million, imprisonment for 10 years, or both. So the 4 words is actually what is causing an uproar in terms of the amendment. And it's because the 4 words have enormous consequences when it comes to the crime as crafted in the Mother Act of 2018. That's why it is a high-stake litigation at the Court of Appeal, which we hope will succeed. But let me digest and try to explain the 4 words and their consequences. There is a legal provision that criminal offenses as crafted by Parliament or any other law should be very specific, in that someone who commits an act or an omission should be very knowledgeable and aware that this act is indeed a criminal offense. In that if there is a law that creates an offense that comes with ambiguity, then that offense should be shot down for being essentially unconstitutional. So when you talk about likely to commit suicide, suicide is a very serious issue. We should treat it as such. Interestingly, until 2 years ago, attempted suicide was a criminal offense in Kenya. A petition was filed under the mental health issues and discrimination, and the High Court again ruled that a question of mental health should not be criminalized. So what can make someone likely to commit suicide? What I'm talking to a member of Parliament, perhaps like Ichungwa, is very annoying. What are you telling people about this law that we've enacted? Do you know that this law, talking about this law, is likely to cause me to commit suicide? So anything can cause distress to someone and can be interpreted as likely to cause that person to commit suicide. So what they are doing cleverly, they are broadening the law to make any act that is annoying to the government a criminal offense. So that if I post, sorry,
I just wanted to intervene.
yes,
Levi, you make a very good point that
Yes.
this is a law that is supposed to clamp down on freedom of expression.
yes,
But there's another part of this amendment that includes the formation or more powers to a committee, the NC4 committee.
Yes.
This particular committee, I'd love for Evans to explain the repercussions of this amendment from that point of view.
I'll just finalize then.
Yeah, please.
My colleague can take over. So that is the issue we're actually challenging in court. And as we speak, the court has issued conservatory orders stopping the application of that Section 27 of the 2018 Act, in the sense that the amendment has broadened it and has made it ambiguous, in the sense that any act that annoys someone else then can be interpreted as likely to cause that person to commit suicide. That's one. I'll just mention another second very important aspect of that law. That is an amendment to Section 6 of the Mother Act that talks about the powers of the government and its agencies actually to close down websites. So it is something we call deletion. It's a very wide argument when it comes to free speech and freedom of expression. Now they give, interestingly, they give qualifications what can make the government actually close down a website. They mention terrorism, religious extremism, cultism, and pornography. This provision actually forms the substance of the petition in Kerugoya by Njeri, because he has taken advantage of a specific provision of the law. I think it was mentioned before that any act or bill that touches on county governments should actually go to the Senate as the custodian of the interest of public county governments. So what happens, this Section 6, the amendment to Section 6 provides that terrorism, pornography, and any website or online entity that promotes the same is actually liable, or it can cause the deletion of or the closure of that website. So Njeri took advantage of a fact that curtailing pornography is actually the function of the county government, and took advantage of that loophole of the law to actually get conservatory orders stopping the amendment to Section 6 of the Mother Act. That's the Computer Misuse Act of 2018. So those are the two issues. Interestingly, there are a few others that are not very controversial, but when it comes to the Amendment Act, those are the two controversial issues. The issue of the fine of 20 million and imprisonment for 10 years, it is actually in the Mother Act. And that's why I refer to the original sin. The Mother Act itself of 2018 curtails freedom of expression in any constitutional view. And we hope that the Court of Appeal will be gracious enough to uphold the law and declare a majority of the 2018 Act as unconstitutional. In the meantime, we enjoy conservatory orders as to Section 27 and Section 6 of the Amendment Act as amending the Mother Act of 2018. Thank you.
Thank you. Thank you so much, Wakili Levi. Give a coffee. I think that was very well explained. Now, moving on to Wakili Evans Ogada, who also doubles up. I can also refer to him as Mwalimu. Mwalimu, there have been discussions around the very same act. There have been discussions around data. People are saying, and there's a big worry among the young people, that these amendments do not require judicial warrants or thresholds of evidence before subscriber data is accessed. That is number one. Number two, there's also concern around the powers, the expanded powers of the National Computer and Cybercrimes Coordination Committee in accessing our pages, our blogs, and apps or even them or making them inaccessible without any court processes. Kindly expound to us what this law does in terms of our freedom of expression, right, freedom of the media, fair administrative action, and right to fair hearing. Asante sana.
Thank you very much. I will be very short because time is well spent. Thank you, Levi. Thank you, Tom. The problem with Section 27, Section 6 have well been highlighted. Section 6 gives Section 6 of the Amendment Act purports to give enormous power to this organ called the National Cybercrimes and Computer Committee, and the powers are enormous. Pull down your blogs for those reasons that are stated. Now, if you look at Section 46 of the Amendment Act, Section 46 envisages that court orders should be granted to pull down some of those sites, get orders to injunct some certain publications. So in essence, even within the Amendment Act, Section 46 and Section 6 are clashing. Now let's look at the Constitution. What does the Constitution say? Look at the powers of the authority given to us, because we are now talking about free speech and we are talking about curtailment of free speech. If you have your Constitution, I always carry mine with me. Article 33 of the Constitution is one of the better elaborated provisions of the Constitution. Article 33(1) gives you the elements of free speech. What constitutes free speech in this country? Then, for historical reasons, 33(2) gives you what is proscribed as free speech. And then the chapeau, Adomanyoba, it's not chapati, Chapeau is the heading of Article 33. Article 33, the heading, that is what we call chapeau in law, uses the expression freedom, the term freedom of expression, which is very wide. I don't want to take you to class. We'll do that on another day. We used freedom of expression as opposed to freedom of speech. And then we have the elements in between, which covers a lot. Certain politicians are worried about their caskets being paraded on social media. Some of you here have been talking about inches and what sort of things with female MPs. They're obscene, they're vulgar, but do they meet the threshold of Article 33(2)? Okay? So that is the legal question, the constitutional question we need to ask. Now, the law, any law in this country that should deal with speech should be structured around 33(1) and 33(2). That is what Parliament can do. In terms of curtailing it further, we go to Article 24. And that's the business of the court. The court now interprets and looks at whatever speech that has been left out within 33(1) and 33(2) and interprets the Constitution to find it whether it's applicable or outside the remits of 33(1) and therefore falling within 33(2) or proscribable within 24. Tumelewana. I hope I didn't lose you. Now, data. Data protection. Your fingerprints, your ID numbers, and this requirement that we have to register authentic data details with our social media accounts. I find it particularly problematic. You remember this young brother called Amenya? He's the one who leaked to us the Adani story. Sindio? Most of you were not born when we have somebody by the name Mutankei. There's a fellow who leaked to the Goldenberg story. Yeah, he was a guy who used to work for Central Bank, and he leaked perhaps Kenya's greatest public robbery. Most of you were not born then. Those are whistleblowers. they will probably use anonymized accounts, and they will leak to us the scandals that are happening in government. Wachanene na the tea that you guys like from Aoko. I'm talking about scandals, real scandals, things that are being done in government. This other guy, what's his name? This other one, this one who sometimes does good things but sometimes insults people. What's his name? Cyprian, yes. They've been doing a good job in terms of leaking and giving us information about all sorts of scandals. If you insist that these anonymous bloggers and people give us their details and credentials, you'll be impacting on Article 34. And Article 34 deals with the freedom of media. And media is now not only mainstream media. We now have what we call citizen journalists. Okay? So another concern, we have international standards dealing with data protection and divulsion of data. We have not met those thresholds, and that is subject of the petition by my good friend Mutuma, the Kagame petition in court. Please follow that. Thank you very much.
Thank you so much. Makofi. Thank you so much, Mwalimu. Moving on to Ray Ondaga, who is also a legal researcher at Katiba Institute. Katiba Institute challenged the mother law, that is the Computer Misuse and Cyber Act then. What inspired you to challenge the law then, and what do you hope to see in this new development, even as we take these new amendments to court? What do you hope to see?
So for you to understand, for me to comment on that issue, you have to understand why Katiba Institute was formed. So the founders of Katiba Institute, Professor Yashpal Gai, the wife, Professor Jill Cottrell Gai, Dr. William Mutunga, the former CJ, and our first ED, Waiko Onyeka, who is currently at Open Justice Society in London, they had to look for they knew that politicians will come after the constitutions once it's been passed. So they had to find a way in which they had to protect the constitution. And the motto of Katiba Institute is using the constitution as an instrument of change. So that's the reason why Katiba Institute was formed, to provide checks and balances now. So one of the things we deal with at Katiba Institute is public interest litigation research, among other things. So they passed the Computer Misuse and Cybercrimes Act 2018. I'd just joined Katiba Institute as a pupil from Kenya School of Law. And we filed a petition and we go to court. By then, the judge there was, the file was put before Justice Makau. Is retired now. Justice Makau totally messed the entire petition. He dismissed our petition. He didn't have merit at all. So we appealed to the Court of Appeal, the same 2018. So we have 2018, 2019, 2020, 2021, 2022, 2023, 2024, 2025. That is when the appeal was had 1 month ago now. But now everything we were fighting for, you came to see happening. Once Ruto came into power and there were protests in the streets, people were fighting for rights, this and that, they used the same computer misuse and cybercrimes as to come after people. Now, the matter is at the Court of Appeal. It has been heard. We are waiting. Now they pass this new act into this new act now. 15th, he signs into Nini. Though we are not part of it, we are part of the older one, the first one now. Yeah. So the first one, everything, our petition was Nini. So we are waiting for the judgment in the first one. So it was heard 1 month ago before a 3-judge bench at the Court of Appeal. We are waiting for the judgment now on that. That is the farthest we've gone. Yes.
Ray, away from all that, Ray.
What issues did you raise in your first petition? And what's so different between how that law looks right now to since you guys petitioned it? You see, the major theme of this thing is stifling freedom of expression. Please speak into the mic here. Yeah, so the major issues with the Computer Misuse
and Cybercrimes Act is stifling freedom of expression. You have the right to freely express yourself. And if that right has to be limited, then it must be provided to the law, by the law. And that law that has provided for it should not be extreme that it stifles you. Yeah? And people post a lot of things online. If I decide to post a person in a coffin, is that person really dead in real life? He or she is not dead in real life. So you're allowed to express yourself depending on how you feel about a certain situation, without anyone or anybody trying to stifle that right to freely express yourself. Yeah.
And I'll then go another round by starting with you. The other part of this is the Privatisation Act.
Okay.
This is also another act that you challenged in 2023.
Okay. So for you to understand the issue about privatization in Kenya, you have to look at the historicity of privatization. So we've had 3 privatization acts in Kenya. We have the 2005 one, 2023 one, and the current one. So before we had the 2005 Privatization Act, parastatals were being privatized through ad hoc policy directives. So that was during the Moi's time. So the minister through the Moi ministers had a lot of power. So they'll make those ad hoc policy directives, which were not transparent, and they also lacked accountability at the same time. So that is what pushed to the having of the 2005 Privatization Act. But now that 2005 Privatization Act also, it put a lot of powers on the privatization authorities. Privatization authority now was also being formed by the ministers, by the Moi government. The ministers by then were being also appointed by the president, and they never used to go these things like vetting and whatever. So with the coming of the 2010 constitution, and also the private sector, and also financial lending institutions like IMF and World Bank, so they had to adhere to the constitution and also kneel down to the financial powers in the world. So they come up with the Finance Act, with the Privatization Act of 2023. So before we file a case at Katiba, we sit down and talk about it. So I'm given that file. I'm given the Privatization Act of 2023, and I'm told to file a petition with regards to it. So when you're filing a petition, there are different ways in which you can look at filing a petition. Now, when we're looking at the Privatization Act of 2023, we attacked the process, the public participation. We attacked the act, the content of the act. And now we attack the privatization program. Within the Privatization Act, it gives the minister, the cabinet secretary, powers to form the privatization program, the authority and the program. So the program is what contains all the parastatals that they want to privatize. And I'll tell you something that is happening currently with regards to that. So on public participation, our argument was that there was no meaning public participation. And courts have pronounced themselves in several times on what meaningful public participation entails. It's on case-to-case basis. If you look at Article 10, Article 118, Article 201 on public finances, this parastatals involves money, public money, and they have to be meaningful public participation. So when you look at how they did public participation in the 2023 one, when they called for comments and the stakeholders who were coming in, they were cherry picking the people who were going before them, people who were friendly before them, you see, so that they will get comments that are favorable to them. Secondly, one of our arguments was, when doing such kind of public participation and calling out for memorandums, you don't restrict yourself to English only. There's somebody in the village who cannot speak English, who cannot read English. So it has to be in a language that he or she can understand and also speak. So that's where Kiswahili comes in now too. On the sections now, we were very specific on the sections. There was section 22.5 of the repealed one, the unconstitutional one now. So section 22.5 provided that since the cabinet secretary is the one that has got power to come up with a privatization program, and he or she is under the control of the executive, the president. So if the cabinet secretary took the privatization program to parliament, and you see the parliament is also captured currently, if it goes before parliament and the parliament does not ratify it within 90 days, then it is considered to have been passed. So the oversight powers of parliament is taken away by the executive. Now then we go back to the privatization program now. Now here is where there was a big deal. So I grew up in the 90s. I'm a millennial born in the 90s. And there's some things that I carry a lot of sentiments in them. KICC is one of them. So growing up in the 90s, Safari Rally was very famous. I had this shirt. I was living at the coast and I was born at the coast. So I had this shirt of KICC, and there's a cheetah jumping on top of KICC. So people used to ask me, "Oh, you've not been to Nairobi, so whatever you are seeing there in your T-shirt is not true." KICC is so tall that a cheetah cannot jump on top of it. So I visit Nairobi in 2000. That was my first time to come to Nairobi. Now I'm 26 years in Nairobi now. So I go to KICC, I take a photo. Zile photos zinakuanga hapo, I have photographers, and so they are edited. So it's a photo of KICC, and I'm on top of KICC. So I keep that photo with me. So I look at the program again. They have KCC there, Kenya Cooperative Creameries. So nothing beats Malaya KCC. Nothing beats Bataya KCC. Nothing beats that. We also have Kenya Seed, a subsidiary that has got Kenya Seed that has got subsidiaries all over East Africa. They are profit making and they don't depend on the exchequer for anything. But they want to privatize them. Now, why are they privatizing them now? Don't forget, KICC is also a national monument under the Monument Act. Ukiangalia doya Kenya, si unaona KICC. When they talk about landmark buildings all over the world, when they mention Kenya, what comes up? KICC, we have got Eiffel Towers in the in France, the Leaning Tower of Pisa and others in Rome. But here now they want to take KICC out of them. So when you go to court, it's like as if you're also going for an interview. Whatever you claim in your petition or whatever you are contesting in your petition, you should be ready to defend it in a court of law. And you defend it very well. You don't look stupid before a judge. So we go to court. So the court agrees with us. No meaning public participation. That one kills the entire act. Bypassing parliament under section 22.5 of the repealed act kills oversight. Now KICC now, our national monument, it cannot be sold. In fact, even in the petition we were arguing, when you are selling KICC, does it include the land within KICC? Do you know how much prime that land is? Are you selling KICC the building, or are you selling including the land? So we beat them. It's declared unconstitutional. It goes down. Parliament rushes to the Court of Appeal now. Instead of the Attorney General. So when you go to the Court of Appeal, there's something called 5-2B application. A 5-2B application is a stay application for a judgment. So they rush there to stay that judgment by Chacha Mwita on 24th of September. So when you go to the Court of Appeal, for you to stay a matter or a judgment, there's a three-part test that you must meet. Is your appeal arguable? Can you argue it? Yes, we say that, yes, they can argue it. Anybody can argue something in a court of law, so long as your submissions, and you win cases on submission and your evidence. Now, will it be rendered nugatory? Will your appeal be rendered, will it not make meaning, or will it fail to make meaning if the stay application is not given? No, the appeal can still continue. Now, public interest. There's a case called Gatirao Peter Munya. So it introduced this limb of public interest. Now, does public interest lie on selling strategic, monopoly, and well-doing financially parastatals? It's no. They sell KICC. Can we get it back? No. So it didn't favor them at all. And in fact, when they were at the Court of Appeal, the judge, may soul rest in peace, Justice Ocheng asked the State Council, how much can KICC go for? You cannot quantify the value of KICC. And before, in that financial year of the 2022-2023 financial year, KICC had made a profit of 1.9 billion Kenyan shillings. So why privatize it?
Ray, I'm really sorry I have to interrupt. Because you're short of time. But I'd love to hear what the other panelists think. Briefly, gentlemen. Evans, what's at stake here?
Thank you. What is at stake is a lot. Ray has elaborately given us the aesthetics values of property that we stand to lose. KICC is not only worth monetarily, but it has aesthetic and nostalgic value for we as Kenyans. My problem with the current Privatisation Act is the role of the public in terms of public participation appears to have been made peripheral. It has been shoved to the side. And I always don't shy away from saying that the Supreme Court of Kenya has sold as short in terms of public participation. That court is making public participation a ritual rather than a normative function of the Constitution. Now, what is missing here in terms of this act? There are certain things, consequential imperatives and audits that must be done before a state asset, that is our asset, before they are sold. We have about 8 audits, and the main types include financial audit, asset valuation audit, legal and compliance audit, human resource and pension audit, operational audit, environmental and social audit. I want you to write this down because I want you to look at this one. It's the most important for you. Environmental and social audit. Forensic audit, if necessary, governance and risk audit. These are about 8 audits. That cocktail of audits is missing from this act. So when you want to sell an asset without conducting all these audits, on what basis are you selling this state asset? The other day they were telling us they're selling Kenya Pipeline. From a strategic national security point of view, why should you be placing Kenya Pipeline on the market for sale? Kenya Pipeline is a stabilizer of last resort because oil is a strategic value for any country. When things are thick, it's Kenya Pipeline that should be feeding the market in terms of stabilization of prices. Why is it that we are in a hurry to sell Kenya Pipeline? It shows you the thicos that we elect and put in government and the stupid decisions they make on behalf of us. Thank you very much.
Mwalimu calls it as it is. So moving on to Mr. Levi on the last question on the Privatisation Act. There have been concerns that this act, when we are dealing with all our public assets, we deal with them through the Public Procurement and Asset Disposal Act. Now, this act does not make any reference to this act. There are also concerns, as Mwalimu has put it, that there's no clear express mention of the Auditor's General role in the selling of this act. That concern has been the executive dominance in as far as how these assets are concerned. And so the question is, Article 1 of our Katiba says that all sovereign power belongs to the people, and that this power is exercised directly or through our elected representatives who are exercising our power. So when we are not in control of our public assets, what will happen to us? What will happen to the state? And how can we challenge this on a legal basis in court of law? Wakili.
Thank you so much. I'll resound what my learned panelists have said and attempt to answer her question in the following way. The colleagues of Prof here, when I was back in law school, taught me that the law is actually interpreted through a lens. The law does not work in a vacuum. Any enactment of a piece of legislation should be looked at through a certain lens. And in this case, I look it through the lens of the current government. What is the demeanor? What is the character of the government that we have in power today? This is a highly kleptocratic government. The government that has been taken to court multiple times, a government that has demonstrated greed when it comes to public resources and even private resources. So when you look at this Privatization Act, we don't look at it in a vacuum, in the sense that we have a responsible government that cares about the people. We have a government with a history of kleptocracy and stealing of public resources. And when we analyze this Privatization Act, we should analyze it through that eye. You can see an intentional effort stemming from what Prof has said to circumvent, limit, and essentially rubbish public participation. In that, even the enactment of the 8 laws, one of the previous panelists actually mentioned, it is meant to overwhelm the public. Kukua Mkenya ni kuvumilia. Every day you wake up, there's a new scandal. That even a constitutional lawyer like myself, I struggle to catch up with violations of the constitutions that happen in this country. They happen every day. It's a daily business. You wake up, you find a new scandal. So when it comes even to the issue of the enactment of the 8 laws, those 8 laws are enacted at the same time with an intention by parliamentarians to limit public participation, and not even public participation itself. They even want to limit public knowledge. And I'll give a good example of the Finance Act 2023 that resulted in the revolution that we had, including the inversion of parliament. That, as I mentioned, I think the president uttering, I heard, for the first time in Kenya, the government had actually put in resources into public participation of that bill. I presented in almost 3 forums on behalf of our clients, but you can see after that time, because public participation is a spirit. It's a spirit under Article 10 of the Constitution, in that a responsible government should facilitate, aid, and put resources to ensure that, to the level best, every Kenyan has a word and has a say in the laws that are being enacted. But you can see now in the recent future, including the 8 laws that were enacted on the 15th of October, there is now an intention of our government. The government is now opaque, like the OPEC 3 or wherever. The government is trying to do things with the minimum bare of what the Constitution provides. Readings, and newspaper advertisement inviting people to publicly participate. But the intention of that government is that there's least public participation, as Ray has said. They want to cherry pick people who are publicly participating. And that's the result of the privatization bill. She has asked about the Auditor General, the Procurement Act. The Auditor General has been filing reports and raising alarms about many budgetary issues. All those alarms and reports of the Auditor General are actually shelved with no government intervention or no government ensuring that there's some level of responsibility when it comes to use of public money. So I'll answer her question in that sense, that the same constitution that provides for Article 1, power belongs to the people, also talks about representative democracy, where the people will be represented by members of parliament. And that's why in court, as Ray has mentioned, we really struggle sometimes to frame our constitutional petitions, because it appears that parliament that is indeed exercising the powers that it was vested and donated to the people is essentially trying to dodge any challenge and put that act or bill of parliament in a constitutional rope, whereby you have to pick how to challenge it. So it narrows down to the people we elect in parliament. It narrows down to the government we elect. We need to elect the government that has the interest of the people at heart. And if you have such a government, such issues like the Privatisation Act will not arise with the sole intention of looting the public funds and resources of Kenyans. Thank you.
Thank you. Thank you so much. Thank you so much. Let's clap for our panelists. So we have 20 minutes to wind up this panel. And so I will take it up to the voices in the room. Kindly pose your questions if you have comments and questions regarding the Computer Misuse and Cybercrimes Amendment Act, as well as the Privatisation Act. Make your questions and comments very brief, because we intend to be out of this place in the next 20 minutes. By a show of hands, how many have questions or comments? Yes, sir. Yes, madam. Yes, sorry.
Hello. Thank you so much for
Kindly stand. We want to see you. We would love to see you.
Right. Thank you so much for your very informative panel. My question is on the Cybercrime Act. I'm particularly curious about data, and especially with regards to our Kenyan laws on the right to be forgotten. This is the right to have any of your personal information or any information about yourself online being removed. This is something that's up and coming in a lot of countries. And with the proposition of, for example, all of our identifying materials like your ID or your fingerprints being used to access social media, for example. Where, as a country, do you think we are when it comes to the right to be forgotten?
Thank you so much. Another question?
And also, if you could say who you're directing the question to, that would help.
Okay.
Hello. Thank you for the wonderful insights. So for me, I would like to know if this thing of privatization goes through, what are the provisions, or is there a possibility that it can be reversed? And how easy or hard is it to reverse it once it goes through? Because I'm just thinking, the current leadership that we have might want to do that because they have their reasons, but maybe another leadership will come in and think maybe it's not okay. So how easy or hard is it for this thing to be reversed? Yeah. Thank you.
Thank you so much. Do we have any other questions or comments? All right, then. So we will... Yes, sir.
Thank you. My name is David. I would like just to make reference to what Prof was saying in relation to the Computer Misuse and Cybercrimes Act. The genesis all the way. First, as Kenyans, we need to be cognizant that it stems from the Universal Declaration of Human Rights. That's where the journey begins. And then it trickles down to within the African continent, we have the African Charter on Human Rights all the way, and other laws. And within the same constitution that we do have, Kenya is a signatory to the same laws, to the international, continental, even regional laws. And then we have our own supreme, which Professor was alluding to, that gives us power. But as we speak, because I speak from a media point of view, this is just one law. But the media industry has done a review of all the legislations. If you add the Computer Misuse and Cybercrimes Act, we have 26 legislations that actually limit all this. But it's only that we speak more of the Computer Misuse and Cybercrimes Act. But there are so many more. Like, if you just remove the Computer Misuse and Cybercrimes Act, you have the Newspapers Act. To give an example, all the newspapers that are published today, before they go out, they are meant to go to they're meant to go to be checked. Let me just say, to be checked by the state to see whether they can go or they cannot go out. It is still a law that still exists. The only thing that probably would that have worked since then is the penal code, which was revised and expanded due to the 2010 constitution. But we still have many laws. And as Katiba and professors have said, and I see many colleagues here who work on those issues, it demands a lot of advocacy to be speaking out. I like how Kenyans always say that, keep on tweeting, they'll hear. You know, that is just it's just like blowing the candle off, and then it will come down, and then it continues. It doesn't really, because there are so many people who do the donkey work. The lawyers who kept on burning the midnight oil, just ensuring they follow through the people in court after the 2024 protests, arrests, etc. There are people who have to do the actual work. And in as much as we say, continue tweeting, people will, sauti zenyu itasikika, yes. But are you doing the actual work? The actual work is public participation. Whenever people are being called upon, participate and just do as much as possible. Like where I work as the comms person, that is the Kenya ICT Action Network, we did submissions to Parliament against the amendments to the Computer Misuse and Cybercrimes Act. But again, even as we speak here, I think it's after you explained, nobody has seen the signed one, unless somebody has seen and they can be able to share with me. Because I've gone to the Parliament website, it's not visible. I've gone to the Kenya Law Review, I'm not seeing it. The only thing that we've been able to see is the petitions and the sections that have been highlighted. So still it's a mystery, as we say. So I don't know how lawyers are treating that, whereby a law that has been assented but is still not accessible. It's a big question.
Thank you so much. Let's clap for the voices in the room. Asanteni sana. So as we wind up this conversation, we will begin with Wakili Levi, who will make your comments regarding to the questions that have been posed. And once you're done with the questions, you will end up with your parting shot. So karibu sana Wakili Levi.
I've actually taken note of two questions from the audience. One was about data and the right to be forgotten. And second one was about reversal of the damages of privatization. I'll take the one on privatization. On data, I'll surrender it to Prof. I'll donate it to him to answer. On privatization, there is something called the perpetuity of the government. The government is perpetual. So whatever decisions this government makes actually bind the next government. So it is very hard to reverse decisions like privatization. As Ray has said, something like KICC, when you are privatizing KICC, it is unclear on the extent at which you can use that property. You've privatized it. That means it is a private property. Whoever has bought that property can decide to do extensions, can decide to build a club there. There's very little you can do to stop that person. And to the extreme, you can actually decide to demolish the building itself. Such demolition, no other subsequent government can reverse. So that's why we are very vigilant in court, because some of these things, the moment they become private property, they can be put to public to buy shares. They can be further transferred to other entities, some of them international, and therefore you lose touch of it. And to reverse that decision becomes a very uphill task. To my conclusion, before I surrender it to Prof, I'll say I'm again amazed that we are here tonight at this time discussing issues to do with our nation. Let's keep vigilant. As lawyers, we'll do our best to challenge these laws, but there's a big limitation that the intention and purpose of the people who enact these laws is not good. Someone, I think, mentioned here about the good side of the law. Some of these laws, he mentioned the Wildlife Amendment Act, appear to have very good provisions. But it's a strategy sometimes by legislatures. You try to, like you've seen the Computer Misuse and Cybercrimes Act, they're talking about very good things that all of us as the public are concerned. Terrorism, pornography. I don't think we are concerned a lot about pornography, but I'm concerned about terrorism and religious extremism. These are two issues that are very important. But the way legislatures do is to package, to sugarcoat something to appear that it's good, but there's only one clause that they use. They want to invoke to actually limit the rights of the people. So let's remain vigilant. And most important over everything, we need to vote for good leaders. The courts cannot resolve bad laws completely. Unless you vote for proper and sober leadership on the presidency and in parliament, people can make the law with good intentions, will struggle, will wander in court, will shoot down this Cybercrimes Act, another one will be enacted, and it will become a vicious and tiring cycle. Let's take our vote. Let's vote good leaders into power. Thank you.
Wakili Evans?
The sister who asked about the right to be forgotten. Quickly, if you look at our constitution has about 40 articles which comprise the Bill of Rights, Article 19 to Article 59. The right to be forgotten is not there. For it to become part of our laws, it has to be interpreted and read into the Bill of Rights, and that is by virtue of Article 19.3b. I don't know of any court decision that has read the right to be forgotten in our Kenyan laws. That right to be forgotten, we are still dealing with the right to have certain things removed in terms of privacy and anonymization, Kenya law reports. That's how we're still dealing with it. We have not reached the European stage, the Western understanding of the right to be forgotten. So I'll want to have a conversation with you how you think we can manage that. In terms of parting shot, Samora Machel, a luta continua. The struggle continues. Power yields nothing without a demand. If we continue and sustain the struggle, and I'm happy that your generation, this young generation, is asking questions, then we will realize full freedom, plenary freedom in the sense that is required. Remember, the framing of a government which is administered by men or women, over men or women, we must first enable the government to control all of us. And when it controls all of us as the governed, in the next place, we must oblige it to control itself. That's a quote by James Madison. How does the government get controlled? Through the Constitution. Protect this document. Thank you.
Asante sana. Thank you so much. Wakili Ray from Katiba Institute.
Yeah, so I'll say something on the Privatisation Act of 2025. I wish we had more time to dissect the act, but we don't. But this specifically act offends so many things from under the Constitution: public participation, access to information, putting more powers on the executive through the cabinet secretary. He makes a lot of things, not involving the Senate, and among other things. Also, another thing to note is that the government has decided to hide the privatization program where the real meat is. So at the moment, we don't know which parastatals they are going to privatize. Yeah. So that is one of the key things we must also look to. Now, in life, you must always be ready to stand for the right thing. The public interest litigation that lawyers do, we go to court, you can't quantify it in monetary terms. Sometimes you have to sacrifice a lot. Sleepless night, your security. I can tell you 2024 was a bad year for us. Very, very bad year for public interest litigation lawyers. But here we are today. We'll continue standing for the right thing, no matter what it costs. Thank you.
Asante sana, my co-host.
Yep. Do we have one more question? I think we might have time for one more question. I feel like we haven't involved you guys enough. Okay, no question? Okay, he has something to say, please. Briefly, very briefly. Did you get a mic to him? No, there's one on that side. It's okay. Yeah, please go on.
Thank you so much for the conversation. My name is Masai. I wanted to know about the issue with regards to the Privatisation Act that deals with government-linked corporations. I heard someone talk about it, but I didn't really understand what that means. And also regards to the public participation, I'm not a lawyer, so I don't know so much things, but I wanted to understand also, is the public participation always done through newspapers, such that only people who go and buy such kind of newspapers get to see, okay, this is the memorandum that the government is seeking. Are there other ways in which the Constitution provides that we can have more avenues like these ones where we come to dissect these matters before they are passed?
Right, thank you.
Thank you.
Think you can take that, Ray?
Okay, yeah. So I'll take the government-linked one. So this is a new concept in the 2025 Privatization Act, the new act. So government-linked companies, those are companies that the government does not have 50% ownership over them. But now, if you look at the Privatization Act, it involves parastatals that the government has a majority stake in them. So, for example, the government only has a specific percentage in Safaricom, right? And KQ too, right? So, this is the trick here. These government-linked entities, they will not be subjected to the Privatization Act of 2025, meaning that the government can play whatever games it wants to play in them. Because they won't be subjected to the Privatization Act. So it's very easy for them to easily dispose those shares, sell them to friends, buy them themselves. So that is the trick. And that is one of the most contentious sections within this Privatization Act of 2025. Yes.
There's a second part to the question about public participation.
It's on public participation. I told you public participation is on a case-by-case basis. One might apply to a certain scenario and might not apply to another scenario. For example, now, conventionally, they usually advertise them. They need memorandums on newspaper of national circulations. Then you send your memorandums either through email or you take them physically to Parliament, or you also call, like us now, we are usually called to go and do public participation. We take and we present our submissions before the committees. It can be jail, like justice, legal affairs, or whatever that is there. It can also be different. public participation, let's say, if it has to be done, let's say in Lamu, the coal power plant, or even somewhere in Nakuru, where people don't understand Kiswahili or Anini. So they'll have to go, even though they call the memorandums to nationwide circulation, they've also have to hold public participation on those specific affected areas, or the areas that will be affected by that particular law or that project that is under will be undertaken. So it's on a case by case basis. It's not something that is standard. One may apply to somewhere else, but doesn't apply to somewhere else. One can lead to the nullification of Nini and not lead to the other one. So it's on a case to case basis.
Yes, yeah, brilliant. I assume no more questions are left in the crowd. I think we can end it here.
I'm Nixon Odari Mrabwa from Kakamega County, and I'm very much happy to be here today on this town hall. I think issues around public participation are very integral, and this is because, in my own personal view, when we think about the most fundamental aspect of the constitution in Kenya, public participation is actually that key thing. Devolution is just a way of administration, but the real devolution was that to the individual in terms of public participation. As I've stated, I come from Kakamega County, and one of the key things that we are doing there is attending public participation sessions that are integral to us. And in that process and time, we are able to try and engage young people to ensure that they are meaningfully engaging in various issues. Though over the last couple of years, one of the biggest challenges we are having is the structure and format of public participation. Given the fact that people have to travel to the headquarters of the county to participate, there is a monetary aspect to it, which then hinders meaningful public participation by young people. But fundamentally, you find that there is engagement and there is a growing interest and enthusiasm by young people and the general public to engage in issues around public participation. But one of the things that I think is a really serious threat to this is issues around misinformation and disinformation, because many a times the real conversation or the real bill is somewhere in a website, but then the information that is circulating online and on social media is quite different, and then that one is what goes out. So I think that is one of the biggest hindrances. So if we can be able to verify and check what we are doing before we comment on public participation, it will be fine. Thank you.
I would like to let everyone know that we are now live. I think it's just been set up. So if you can kindly follow Bunge La Mayut, they have shared the link. You can reshare that and invite more people to watch.
So yeah, another act that was passed was the Air Passenger Service Charge Amendment Act. Again, if it has amendment in the title, it means there's a principal act. So I think the information that I'd like to share at this juncture is the finance bill as it is, huwa si sheria moja. It's a compilation of amendments from different acts that deal with finances. So then they are brought together and then they form the finance bill. So then, for example, the government has a budget of 4 trillion. They've done their budget, wako na budget ya 4 trillion. Lakini wanaona with the existing tax framework, we can only raise 3.9 trillion. Inamaanisha wako na deficit ya 100 billion, sindio? So then what they do is they look at the existing tax framework. Wanasema, for example, VAT tukiongeza kwa maziwa kidogo, na tukiongeza excise duty hapa, na tukiongeza hapa hivi, to combine, we will cover the 100 billion deficit, yeah? So that is why if you open the finance bill, it's 136 pages here this year and the previous years, you'll see it has different, I'll say, acts within it. Utaona excise duty amendment, utaona VAT amendment in it, because they are making amendments on different laws. Among the laws that you can raise finance through is the Air Passenger Service Charge Act. It's an act already in place. Why? Kwa sababu wale watu wa ndege, sisi wengine tukiwa barabarani, wale wa kulipa tickets za ndege, there's a tax on your ticket called the Air Passenger Service Charge. That tax is usually used kutengeneza barabara za ndege huko uwanja wa ndege na tourism etc. Yeah. The problem, and I saw there was a bit of information that that charge has been hiked etc. Not particularly. So what this law came to do was to harmonize everything. Initially, we had a tourism promotion fund. The tourism promotion fund collected tax. This tax, KCAA, Kenya Civil Aviation Authority, wanted a claim on it. Kenya Airports Authority wanted a claim on it. And then, watu wa tourism wanasema, haitusaidi. We are not feeling the impact because one, it's opaque, and two, there is overlapping mandate. Everyone wants a claim to ETTC. Na ukiangalia, watu wenye wanakuja na ndege sana ni watalii, si ndio? So then the Amendment Act wanted to make an amendment to the Principal Act to ensure that tax zenu za tickets za ndege also promote tourism. I think it's really progressive because then it disbands the Tourism Promotion Fund and sets up a new fund, and they call it the Central Fund, the Tourism Fund. Yeah? So that Tourism Fund then helps enhance how it's a central place, pesa za rushwa hapo, and then we enhance, so we make repairs to our roads, sijui kwenda national parks, we make repairs to fence za national parks, etc., so that tourism in Kenya is enhanced. That is basically what the Amendment Act came to do. The Air Passenger Service Charge Amendment Act of 2025. Shukran.
Thank you so much, Mamburi. I think we're clear on a lot of those particular acts, but I have one question regarding the tourism fund. How do they... So is like the tourism fund solely raising cash from the air tickets, or are there other funds?
A good question. So the tourism promotion fund, yeah. So the air passenger service charge, unaona hata from the name of the act, the charge, the tax in itself comes from that. But the tourism promotion fund, the problem was it had fragmented distribution of charge. After it has been charged, the model, yeah, how do we give KCAA, Kenya Civil Aviation Authority this, Kenya Airports Authority this, hotels are having a demand on the roads leading to the hotels, the parks, etc. That was where the problem was. But now a consolidated fund has been established and now a proper model of doing that. Yeah.
Okay. Thank you for clarifying that. Does anyone have a question about the Air Passenger Service Charge Act? Anyone? Are we good on that one? Okay, we're going to move swiftly to Lewis. Kindly take us through the Virtual Assets Act. Is that what it's called? Like, kindly clarify what it's called and also what it entails, briefly.
Briefly. it's a First of all, can I just ask a question, right? How many of you have interacted with Bitcoin? Cryptocurrencies, virtual assets? How many of you are techies because they're the ones who interact on a lot of these things? How many of you? Okay, quite a number, right? But let me start here. I like giving, and like Mamburi, I'll just highlight things across the bill, but I like giving, because this is the first law of its kind. It's not the Virtual Service Act, it's called the Virtual Assets Service Providers Act. So I want to give a bit of history to this, right? If you go back all the way to 2015, the then CBK Governor Njoroge issued a statement, and he took a very cautionary stand towards engagement with virtual assets and cryptocurrency generally. And at that time, he attributed it to the risks around volatility and illicit financial flows, largely, or it's and then subsequently, from then 2015, those of course development, right? There's uptake continuously, and then we get to 2022. 2022, Kenya undergoes something that's called a mutual evaluation review by Financial Action Task Force, which is FATF, right? The fertile regional body within the Eastern and Southern Africa region is the Eastern and Southern Africa Anti-Money Laundering Group. So they come here for a peer assessment. And the outcome of that mutual evaluation review was that one of the areas that we were found to have some level of deficiency was on the regulation of virtual assets and virtual asset service providers. There was no existent law on how to regulate that sector. Fast forward, we go to 2024. We are grey listed. That's in February. And one of the things we are supposed to meet, one of the requirements we are supposed to sort of meet to get out of this grey listing, which means that we are a jurisdiction under increased monitoring. This means that what is implied by increased monitoring is that in the global financial architecture, even when other countries are engaging with you, they're engaging with you from a point of liability. So correspondent banks, for instance, will engage with you from a point of liability. You'll have a problem when it comes to foreign direct investment because you'll find the financial integrity of your country is being brought into question. So we move towards, so I think the government then decides that we ought to sort of implement some policies to sort of make sure that we have oversight over virtual assets and virtual asset service providers, generally the entire digital financial ecosystem on virtual assets. And what it does is then, first of all, there was a first draft of the bill, Virtual Asset Service Providers Bill, in 2024. That is different from what we have now as an act in 2025, which was a bill reintroduced this year. And that at that particular time, what they did was they had consultations. A lot of the actors who were consulted were from the private sector, who have expertise from that level of actually engaging with virtual assets on a daily basis, and not like us, who are from the CSO space, who actually engage on it from the anti-money laundering and countering of financing of terrorism space, right? So they decide to engage them. And one thing that is notable and differentiates the 2024 bill and the 2025 bill now, an act, is that one of the things was on regulation, who's the supervisory agent for the sector, right? Which entity, which authority supervises the sector. At that time, on the 2024 bill, the suggestion was that we were going to have a virtual assets regulatory authority, which in the 2025 bill, now an act, is no longer there. Because what happened was those powers were then given to CMA, the Capital Markets Authority, to oversee actors of virtual asset service providers who oversee the exchange. So, and secondly, Central Bank of Kenya to oversee payment, your payment platform. So let me backtrack and take you back to now the introductory levels of what we have in this bill, right? So this bill, and I think the point of misinformation could easily come from, and I've not seen a lot of controversial takes on this one, and I believe it's because it's an introductory bill. There's no act, there's no act like this before, and I believe that we'll see a lot of questions arise once the implementation process starts. But to start off on what this bill caters to, the provisions basically are very distinct, and they say that we are not regulating virtual assets as such. We are regulating the virtual asset service providers, whoever engages in the provision of the service. That is a person who provides the interface, the platform to actually trade, transfer, acquire virtual assets. And in this sense, the definition of virtual assets in the very basic sense is the digital representation of value. You have attributed value to, let's say Bitcoin, for instance, because Bitcoin is the most common, we all understand Bitcoin, right? But what the bill does is I think one of the points I saw someone argue about was that you can't regulate the network. That's not what the bill is supposed to do, or the act is supposed to do. The act does not regulate the underlying platform, the technology, which is the network. Neither does it actually regulate individuals. Peer-to-peer transactions are not regulated. So if I engage in selling you Bitcoin and you bring it back and you sell it back to me, that transaction, that process of the two of us transacting is not regulated. What is regulated is the platform. So that platform that offers you that service, your Binance. Think a bit of, some of us know about Binance, right? So that's the platform that's regulated. And then something else that does stick out in this is the fact that from where the service providers are being regulated, it's that one of the key things that they're supposed to do is to actually provide information. First of all, set up offices here. That's a first set of offices, get license, which is renewed annually. And then subsequently, anyone who knows compliance when it comes to anti-money laundering and countering of terrorism and proliferation of financing or mass weapons will tell you that the other thing is now your compliance is sort of bank grade or bank level, where you have to know your customer, which is KYC. You have to do your due diligence, enhanced due diligence for politically exposed persons. All those requirements come into play. I'm looking at this also from, and I think this is why it is important for us to understand it, is the implication to the individual. First of all, you need to understand there's a gray area around how easily an individual could easily offer services without understanding the law and therefore be categorized as an unlicensed service provider. So there needs to be more clarity on that and understanding and education on that, so that individuals don't find themselves being followed up by authorities because they engaged in service provision. The other thing is, now us as citizens or us as individuals who choose to engage in the trade of virtual assets or choose to use virtual assets as a transfer of value can actually now be protected from harm to some level. Although restitution mechanisms haven't been put in place, I'm hoping that once the regulations come into play, we'll see those defined. But as it stands now, there are sanctions towards fraudulent sort of practices by virtual service providers. And also the fact that if you don't comply with some of these provisions and requirements, you could easily be fined 10 million as a company. That could go up to, I think, 20 million from the Act. And then there's, of course, imprisonment terms. And then I think to sum this up, and looking at the whole Act as it is that this seems to be an effort by the government to actually get off first the grey list, one of those. And I think we ought to understand that I'm not saying that's the only origin of the bill, but that's what gave impetus to the existence of the bill and now the Act. There's also the question of taxes. Previously, I think in the finance, it was expunged though. It was the digital asset tax, DAT. It was supposed to be, I can't remember, 3%, I guess. And then subsequently now you're going to have exercise duty, but on the transaction fees that or the gain that the service provider gets from the transaction, the margins they get from that. And to conclude, because it's a very robust bill, I think the numbers on these are very interesting, because the existence of it means that for those, the amounts that have been floating around is like 2.3 billion USD in transactions in stable coins going across monthly. What that means is then we have oversight over these funds and therefore curtail on illicit financial flows or money laundering within the virtual assets piece. If you have any questions, I'd be happy to take them. I think that's it.
What Bitcoin, I think Thank you so much. Let's give it up for Lewis. You see, I think we do have a question.
No,
Yeah.
I just, before the question,
Yes.
I wanted to do quick key takeaways from what Luis has presented. So one, sijui wangapi wamewatch Queen of the South? Queen of the South? Sindio? Kumbuka ile siku Townhall. Nakumbuka the season where she was selling drugs, and she was a drug dealer. And then she started using crypto so that she would send crypto to her pedi, and then if you want to pay her, you pay her through crypto. So that is what Luis is basically saying. A lot of money laundering happens through crypto because of the blockchain, but I know it happens through that, yeah? So then, because of that, we were grey listed, yeah? A lot of money laundering was happening, we were grey listed. What does it mean for us as a country to be grey listed? He's mentioned investment banks. Yeah.
Platforms.
So yeah,
an issue, and then foreign direct investment because you viewed as a liability in the global financial architecture in terms of financial integrity.
Yeah,
that's
so I'm assuming even when we are taking loans from World Bank and IMF, our interests for the loans, by virtue of the fact that we are grey listed, would be higher. Yeah, and then if investors want to come to invest in the country, that would also be an issue. He's mentioned also the fact that it is not individuals that the Act seeks to regulate, but rather the people who provide the service. I remember there was WorldCoin. Yeah, WorldCoin is a virtual asset. Yeah, so now it's not sisi watu tulienda to get the WorldCoins, but rather the people who are offering the service. So an excise duty tax is charged on them on their transaction etc. So I think that is what I wanted to summarize. Yeah.
Awesome. I think we do have a person at the back with a question. Yes. Gotta try and get the mic to you.
Hello. So I had a question with the bill because you did talk about digital assets. So I wanted to find out the digital assets that we're talking about, is it strictly financial, like NFTs, cryptocurrencies, or is it going to be digital assets as a whole? Because that complicates things when we get into things like personal data or intellectual property, for example. And also, you said that it's not coming for individuals, but service providers. In today's day and age, the difference between an individual and a service provider, especially on the online landscape, when we're looking at things like intellectual property, for example, I think that line could be very easily blurred. So is this strictly financial digital assets or digital assets as a whole? Thank you.
Good question, because that's one of the controversial points of the bill, right? And it's the introductory, not a bill, act. Sorry, I keep interchanging these words. So the question is, the act in itself is not exhaustive, and I think that's one of the criticisms of the act. And if you look at it, it's one of the recommendations. I think it was Yellow Card of Virtual Assets Chamber who offered a recommendation in the while the act was a bill in Parliament, and tried to sort of delineate these definitions, right? And I think that was rejected by the members of Parliament then, and they chose a very general definition of the same. I think the argument was, for a start, let's have a legislation in place, a policy that gives guidance and clarity on some aspects of these. So my assumption is that the regulations might be clearer on the particular financial assets in this sense that are being financial and non-financial assets that are being uh, uh, regulated in that sense. But I know for a fact stable coins is part of it. NFTs are also part of it. E-money is not part of it. I remember looking at that and then forgotten one of them, but e-money is not part of it. That's what I remember. And then the question on the bloodlines between the service provider and the individual is a very good question, because that's the other criticism of the act as it is that it locks out open source teams out of the entire conversation of virtual assets. Open source teams and MSMEs who would also want to be a part of the process or would want to engage in the practice, because then the compliance, of course, the barriers to entry present themselves. Compliance costs, for instance, you have to have a board, you have to set up an office, you have to get your licenses every 12 months. So that means that you have several barriers to entry and costs that open source teams and MSMEs who would actually like to have platforms or would actually like to engage in the transfer and trade of crypto or virtual assets won't be able to do so. But I think that's a question, and sorry to add this, I'm almost getting done. That's a question the South African legislation tries to tackle very well, because it tries to pick up virtual asset service providers or individuals from a very nascent stage. And I think if you look at their registrations since 2022, when they had the regulation, because I don't know if they don't have the act in itself, they have a provision inside the regulation. And then what it does is that it enables them to register around 248 virtual asset service providers, but across the system. So it doesn't lock out smaller players. But then I agree with you that that there's some bloodlines and that there's need for clarity and understanding of the act to know that when are you as an individual engaging in trade, transfer, and providing brokerage service, for instance, or exchange in that sense, so that you're not sort of caught off guard. But yeah, let's hope the regulations, and as we go through the implementation of this act, because I'll give the government kudos at this point because it's still very new, and maybe its iterations in terms of amendments would see significant change and better definition of terms. Thank you very much.
I think we'll have to move on to the two land acts. If you have any questions, Lewis is still around. You can ask him right after our panel. We're going to move to the two land acts that were also passed. We have the Land Amendment Act 2025 and the National Land Commission Amendment Act 2024. Yeah, 2020. Yeah, also 2025. I will give Hilary the floor. Yep.
Okay. Hi, guys. Quick question. How many of us have benefited from inheritance of land at home? Wangapi wamepewa land na mzae? Moja, mbili, tatu. Okay. Thank you. Haya. Wangapi? How many ladies own land? Thank you, your Mheshimiwa. Nice. Good. So I think even before I begin, I always struggle just to wrap my head around the perceived disinterest of youth on land matters. Kama we si wakili wa land, ama we si surveyor flani, stories of land, not as exciting as Bitcoin, right? Not as exciting as the laws speaking on cyber crimes. But then allow me very fast to speak very briefly about the two Amendments Act, being the National Land Commission Amendment Act of 2025 and the Land Act, also amended in 2025. Two principal sections that the National Land Commission Act seeks to repeal and amend completely, which is section 14 and 15 of the Act. These acts zilipitishwa 2012 initially, alafu ndo zikakuwa amended just this year. As practitioners in the land sector, we don't seem to be having so much problem with the amendment as it is, lakini there are issues that still zinaendelea that are historical. So let me start with the National Land Commission. We all know the commission, right? Tunajua commission. Maze mmenyamaza sana. I request you speak, and I see very intellectual faces looking at me. Mnajua National Land Commission, right? So the commission was established huko. The first commissioners were sworn in 2013 hapo, sindio? Mnakumbuka Swazuri. You remember the good professor from the coast comes from Mamburi's village. And then the commission, one of the things that when they came, or rather they came into office, we were very excited. One, because it was an independent office, devoid of any compulsion from the presidency, as it were. Because then previously, the commissioner of land, alikuwa tu jamaa ambaye alikuwa anapeana public land to, if you are president's crony, their friend, you have got large tracts of land. So we all know all the political who is who had a lot of land. But then what the substantive amendments to the National Land Commission Act, Section 14, one was speaking on grants and dispositions. So Section 14, Part 1, gives the Commission 5 years within coming into force of that section for it to look into grants and dispositions, or rather dispositions of public lands issued before 2025. That's the 27th of August when the act came into play. So not contentious per se. It's an effort to sanitize the sector by just ensuring that these dispositions are reviewed within 5 years. But just one thing that practitioners within the sector seem to be having a problem with is that the Constitution gave a mandate in perpetuity to the commission, but then Parliament seems to want to pigeonhole it within a certain time, which is the 5 years. And we'll also look at the other section, which also seems to have the same provision. But then just a section of this act that seems to be problematic, and particularly to lawyers, is 14 Part 7. And this is what it says, that no revocation of title shall be affected against a bona fide purchaser or valid for value without notice of defect. So hii ni ile provision ambayo inaongelea mtu ambaye ana buy land. Now I know many of us in this room have either been swindled in a way or the other about land, si ndio? And sasa the more interesting part is that how is your land? Are people at the ministry? So that's very confusing, because ona, umechukua land yako, umeenda ministry at the house, bado unabakia, umechukua do yako, you have spent, and then you are still swindled. So there is a Supreme Court ruling that said that the buyer and the seller of the land, it is within your mandate to do your background search. Very contentious. A lot of tears. A lot of people have been swindled out of their land. Old women in the ministry, you find them just there. And, land is very emotive. So this provision seems to take away that responsibility. But then the Supreme Court in its ruling said that a title is as good as it roots. So you cannot validate an illegally acquired title by claiming innocence. You must conduct due diligence, both to the buyer, both to the seller. Please, my youths, uko na do yako, unataka kuchangamkia plot, please do it through a lawyer. Go and find an advocate and ensure that you do it legally and procedurally. Please do your background. Don't be in a hurry. Another section, section 15 of the NLC Act. Now, this is a bit emotive, and this is in regards to historical land injustices. Now, one of the mandates of the National Land Commission was to investigate historical land injustices, either by its own volition or by an individual, a county or national government person that has requested for such a case to be relooked at. So now these sections have substantively been repealed and amended to go back to 1895. 1895 rings a bell. Wanahistoria, 1895 nini ili happen? 1895 nili happen? I don't want Wakilis here to respond. Uko nyuma, nini ili happen 1895? We formally became a protectorate. Sasa, imefanya kitu poa, by the way, because now the historical land injustices have, when the British, I always call them the colonial usurper. They are not our masters by all means. They're just usurpers, a group of thieves that came and stole our land around here. So what happened in 1895, we formally became a protectorate, and they came up with laws that were unjust. Just a lot of legalists, they used their mother tongue against us. By that time, we weren't very competent in their language, and they came up with laws, declared us a protectorate, declared that all land, we are just inhabitants in good faith, and very wild things that are just pure comedy if you look at them. But then later, so this act pays allegiance to that time period, and by saying that now the commission can open up a Pandora's box indeed. The Sultan owned the coastal land strip all the way mpaka Zanzibar. The Talai, the Libon Act of 1934, Apo, where the Libons, because they were giving trouble to this usurper, they were pushed to Lambwe Valley in Gwasi, my village, where there was sese flies and what have you. There are two Maasai treaties of 1904 and 1910 that really displaced our people out of their land. So this, I think, to this extent, this is a good act because it sanitizes some of this, save for this section 14 part 7. But then the historical land injustices, when we discuss with the officers of the commission, their discomfort is a time period that Parliament has imposed on this act, which in and of itself is unconstitutional, because then the Constitution gives the mandate to the Commission to investigate. It has not given a time period, but then Parliament seems to give a time period. So that is a bit problematic because we know that the previous commissioners did some effort. They looked into a lot of historical land injustices. They didn't finish, but then some effort was made. And trust me, guys, mkiangalia hizo historical land injustice, they're very emotive. They're very emotive because land is emotive. As I finish, may I say that land is a very significant resource. It confers on you both your identity, even your name. I'll still use Mwamburi. Mwamburi is a Taita because it comes from a piece of land, okay, known as Taita. Sawa? It confers on him both an identity and a name because we call him Taita, not because he comes from Kiambu, because there's a piece of land we had somewhere, Undanyi, Matate, called what? Taita. So land becomes so significant because laden within it is our cultural maxims, identities, and what have you. The Land Act, the amendments to the Land Act, very minimal, just section 14 that compels the registrar to actively register public lands. We all know that the only time we saw small children being tear gassed in our good nation is when it was pertaining to public land, because there has been a greed or an avarice towards public land, because they're perceived to be entities that unscrupulous fellows can always jump on. So I think these are good amendments, but then laden within the discussion on land are still historical land injustices that are yet to be addressed, but also present day injustices that continue in our present society. So that is what I would say in a nutshell in regards to the Land Amendments Acts of 2025. Thank you.
Thank you so much. I think we'll just take two questions, and also we'll lean into our experts in case there's anything to add. I have a question regarding, there's a screenshot, I will say, that was shared online that was talking about freehold land. And people got really mad about this, and they were like, this is in this act that has been signed and we need to repeal it immediately. What is that act that people were sharing, and what is the disconnect between like when the acts are signed and when Kenyans can access them? Because sometimes when you Google, like the thing that comes up is like an old thing, and you click it and you start getting angry at your computer. Like how do you get like the actual land documents? Like, does the land ministry publish them, or how do we get this the correct information every time?
Thank you. So the issue of freehold versus leasehold, there is an attempt and a recommendation that land within municipalities, within urban areas, within areas that have been zoned for development, will revert from freehold to leasehold. Again, open for argument. Because such lands, then the period reverts to 99 years, and then they are subject to some payments, and it's normally for maintenance. But then this is contentious because freehold was such a comfortable place that most people are owning their land as freeholds. But then if you revert it into leasehold, good as the recommendation may be, because then government says that in giving a leasehold, we are opening the space for business, we are opening the space for better services to be offered to you, be it by the municipality or the urban area that you are in. But then the issue becomes that many of the people that hold such titles haven't gotten any services from the governments that they speak about. No roads, no service whatsoever. So this is going to be a potential clash, and I'm seeing legal action against such a provision, because then there are some people that feel that that service hasn't been rendered to them whatsoever. On to your second question, in regard to where do we get such information? I have started my discussion by saying, even before I became a practitioner in the land sector, land matters seem mundane. And even to the lawyers, land law is quite technical, and very, the laws are quite lengthy. So the interest of youth, even on agriculture, we were in a forum today, and the average age of the farmer in Kenya is 64. 64 years. That's the average, courtesy of a research conducted by AGRA. So that explains why then the youth disinterest. Is it that we don't get the land from our parents? Is it that we don't have money to transact on it, or is it boring and confusing, so much so that the distinguished lawyer who does land conveyancing, or the surveyor, or a practitioner in a way or the other, holds the bulk of information on land? And indeed, you are safest with a lawyer. If you want to do land conveyancing, you are safest with a surveyor. So most land is held by practitioners, the professionals, but then the institutions that are mandated to conduct civic education and we give them budgetary allocation every year is the Ministry of Lands and the National Land Commission, as far as public land is concerned. Yeah.
Thank you so much, Hilary. We'll take another question from the audience. Okay, I think you have a few. You get
Sorry, I missed part of your presentation. I just had a quick question for you. You're a land practitioner. There's been ongoing digitization of land records. Either of the pieces of legislation, have they captured that, and to what extent? Thank you.
I think we'll take another question and then you can answer both of them. Yep. There's I think someone at the back. Could you lend us?
Hello, my name is Hannah Wamoyo. I'm a lawyer, and my area of specialization is natural resource law. So, for me, it's a comment and also a question to the practitioners. For the National Land Commission Amendment Act, for me, it's a whole contradiction. You've explained well Amendment Section 2 and 3, the one purporting to, the one amending Section 14 and 15. How do you reconcile the aspect of no revocation for that bona fide purchaser and the aspect of historical injustices? What justice is going to be given to these people who will, make this claim that their land was subject to the aspect of historical injustice? Then, does this act, what becomes of the agreements that were executed by the British and the chiefs, the ones who handed over that land? And since then, land has changed hands, as in title has been changed. So how do you reconcile the whole story of our colonization? Thank you.
Yeah, just quickly, was there a person with a question? Yes. Yeah.
Evening. My question is, you stated that when it comes to land, public land, it should be clearly defined what is public land and what is private. In a matter where there are owners who are within a region where there's a lot of infrastructure. So, for instance, I have property within Eldoret, the international airport. When it comes a time where they will like to expand, I know they offer compensations so that you can relocate. But my question is, when it comes to a matter where that land is not bought, but it is inherited land, and it is willed that that property should not be for sale at any circumstance, what will happen then? Will they build around it? What will happen?
Yeah. So
That's all?
briefly to
So,
all those questions.
Thank you. I will, because I'm not a lawyer, I'm a practitioner. So I will leave the legal aspects of it to my colleague to respond to. But then I think that having been said, in terms of digitization and digitalization of land, the Sectional Properties Act try to pay allegiance to part of it, particularly land that is owned in apartments in urban areas. I think it tried to regularize that. I wouldn't know the particular act to that, but then it was a good attempt and a very fair attempt by the ministry to ensure that you can do searches and you can have more transparency and accountability on land. My colleague that asked the question on historical land injustices, and that is the problem we have. And that's why we are saying, as people that conduct advocacy in the land sector, is that this is going to be a huge issue because most of these lands historically, by 1900s and what have you, right now they have changed more than 10 hands and what have you. So then that is a Pandora's box and something that the National Land Commission will have to face head on in trying to determine some of these historical land issues. So I'll take those two and over to you, Mambori.
Yeah, so quickly, I'll want to respond to the first question on the National Land Commission Amendment Act. So, one, Section 14 and Section 15 vile zilikuwa in the Principal Act, they had timelines. That issues dealing with transfer of public land to individuals and granting of public land should be discussed and zimalizwe within 5 years. That was there in Section 14 of the Principal Act, yeah? So, 5 years, he said, Land Act, the Principal Act, it's Land Act 2012, commencement started in 2013. So 5 years lapsed, yeah? Sindio? But the issues still remained. So the new amendment, what it's trying to do is to give us another 5 years. But then the question is, si bado hizo zitalapse, so why keep us giving 5 years when the Constitution itself has given the Commission all the time to solve these issues? Section 15, the same. It had a time cap of 10 years, that all historical land injustices should be discussed, solved, whatever, within 10 years. 10 years from 2013, 2023. So every time Commission ilikuwa ikiulizwa na watu Rendile, Taita, wapi, when can we solve this? Wanasema, hiyo mandate mida ishapita. So then the new amendment is to also amend that and introduce another time cap of 10 years. The problem is, zitaisha tena without the historical land injustices having been exhausted. So then the issue is the time cap. We want the mandate without the time cap is what a lot of people are saying. On the issue of private land, you have your private land, government wants to build an airport, a road, etc. And there is a will saying categorically, this land is ni shamba ya kurithiwa, haifai kuuzwa, etc. Unfortunately, through a process known as compulsory acquisition, the government can acquire even private land to build. So law will always override a will. Law will always override. Hiyo watakwambia ni sawa, ni wishes, ni maono ya mkufi, lakini airport lazima ijengwe. So kitu tutafanya ni, we will compensate you the value of that land, or we reallocate you if you still want land of the same value in another place. The Constitution gives that mandate. Also, the Constitution clearly outlines what is public land, what is private land, and what is community land. Yeah, so you can read watu hata wamepata katiba sahi, angalia from section 60 to section 65, even the mandate of the National Land Commission. So then, yeah, public land is held by county governments in trust for the people. Community land is held by county governments in trust for the people. Ni ile tunasema hii shamba ni yenu kama jamii, kama jamaa, lakini tumeishikilia kwa sasa. So then in community lands, communities can be given titles to that land. So you're given title and then you can utilize that land as a community the way it is. So those are the differences, yeah.
Thank you. And just 1 second. The principle that Wakili so well put is the principle of eminent domain. I would just invite you to go and Google eminent domain, where government reads has got the radical title. Kwa hivyo ikichukuliwa ardhi yenu, don't despair. It's not taken absolutely, but then you have got grounds to contest. You can go to your lawyer, contest. Even the amount they have given you, you can also contest. Another thing, just a second, this issue of historical land injustices, and thank you very much, Wakili. Kama, if the other ones, we weren't able to deal with them with a period of 5 years, because we had 5 years to lodge, 5 years for the commission to hear. Sasa imagine kuanzia 1894 up to 2010 August. That is such a long time, and we are sure, but we don't anticipate it to be that way. We are sure that the commission will have a bleeding nose going forward, but we only hope that they will try their best to listen to as much historical land injustices as they can, and at least recommend determination going forward. Yeah, thank you. Back to you.
Thank you so much, Hilary. Give it up for all our panelists one more time.
I have participated in public participation. It is an important process of affirming citizen voices in governance. And it is one of the things that we push for as an organization and in the work that we are doing. At the moment, I have experience in participating in public participation. The thing is, information sometimes is available. Actually, most time is available. And sometimes this information is complex, it's too much. And it is sometimes for citizens, it can be, when it is too much, when it is available at the same time, all of it with a very limited time for participation, it becomes very difficult to engage substantively in that process. This is one of the strategies that the government use, or the duty bearers use, to undermine constructive criticism in government policies. For instance, when you look at the 8 bills which we are critiquing right now, they are very important bills. For instance, the land, the cybercrimes amendment bill. These are very, very important bills that inform on what civic space should be like, that inform how we operate in our civic engagement. But to see what the government did, the process was done quietly with very, very limited information, and where it was available, that was not properly given to the citizens. So it undermined substantive engagement of citizens in this process. So there is more work that we need to do as civil society advocates. And that was my experience.